Well, this video we're going to talk about new value. This whole video is about what the subsequent new value defense is about and examples of it. It's found in section 547C4, and during the first case we'll go over the whole statute. This is a Court of Appeals case in the Sixth Circuit. And the question here was whether new value, and I'll talk about what that means, can be either contribution to capital or an extension of credit, a loan, or whether those forms of payments back to the debtor after receiving transfers from the debtor are unacceptable as forms of new value. Okay, so the facts of the case: this debtor was in the paging and wireless business, and the defendant in the clawback action that later took place was one of the owners, owned 30% of the company, and he either lent the money, he lent $140,000, $500,000 in the year prior to the bankruptcy, or he invested $140,500 in the year prior to the bankruptcy. It's unclear, and it was not decided by the Court of Appeals. Anyway, he cut checks in that amount to the company before the company filed for bankruptcy. And he was paid certain sums back, apparently. In the opinion, it doesn't state for some reason exactly what he was paid back and when he made the loans, or whether the $140,500, whether that was one check or many checks. The opinion doesn't go into it. It's not really relevant. It's relevant, but not relevant to the specific issue that the court was dealing with. So, the defendant received, probably, I would assume, repayments of a loan, if it is a loan, during the year prior to the bankruptcy. And there was a trustee appointed, and the trustee saw that this defendant was getting payments. He's an insider. And he sued the defendant for a preference to try to get that money back into the estate to redistribute post-bankruptcy. And the defendant argued, well, after I received whatever payments the trustee is trying to get back, I contributed money to the bankruptcy estate. I made a loan, and the loan is new value. That should count as new value. And the trustee argued, you know what? That wasn't a loan. You got money from the estate, and then all you did was invest more money as an investment in the debtor, and that shouldn't count as new value. So the whole principle of new value is you get money from the bankruptcy estate, and maybe that's allegedly preferential and the allegation is that the debtor is insolvent. So it is preferential because you're getting more than other unsecured creditors, assuming there are other unsecured creditors. Other unsecured creditors, in theory, are getting less than 100 cents on the dollar. They're being paid after the bankruptcy filing, and if the debtor's insolvent, automatically they're getting less. They're getting a percentage of what they're owed, and you're getting 100% of what you're owed. So you're being preferred, and the question is, do you have a defense? And the defense here, the new value defense, is, okay, so you were paid, it doesn't specify here what this defendant was paid. Let's say this defendant was paid $25,000, and then after he received the $25,000 payment, he made a loan to the debtor, or according to the trustee, invested in the debtor in the amount of $30,000. So the argument and the rationale for the new value defense is, okay, you were paid $25,000, and maybe that was preferential, but you contributed more equal or more to that after you were paid, and you're not getting that back. And another issue is that this payment that you're contributing to the debtor after receiving the preference, it's unpaid, and that's a complicated issue whether it needs to be unpaid or not. I'll deal with that in another case. But generally speaking, the concept is you're not getting that back. So you got 25,000 in the example I just gave, and you're giving back 30,000, and the 30,000 you're not getting back. So you're replenishing the estate. You got 25 and you're giving back 30. So the estate's not harmed by these two transactions. Unsecured creditors are later not harmed because, in essence, you're not diminishing the estate. You're getting, but you're giving back. So that's what the subsequent new value defense is all about. So the issue here is whether this defendant, the new value that he was transferring back to the debtor after he received a payment from the debtor, whether that was a loan, whether that was an investment, or what was it? Could it be counted as new value? If the trustee is arguing if it's an investment, you really shouldn't count that as new value. Well, the court went to the definition of new value, 547.82. And new value means money or money's worth in goods, services, etc. The court focused on the issue of the language of money or money's worth. And the trustee argued that money is qualified in this verbiage by goods, services, and new credit, and it can't be an investment. And the Court of Appeals disagreed and said Congress wouldn't have written money or money's worth. It would have just said money's worth. And so money, pursuant to the language of this definition, is also new value. Whether it's an investment, whether it's a loan, doesn't matter. And that's a decision. So the specific decision here that the Court of Appeals was looking at was, whether an investment of capital after receipt of a preferential transfer or alleged preferential transfer, maybe there were other defenses, can be new value. And the answer in the Sixth Circuit is yes. It can be. You can make a new investment, and that's replenishing the estate as much as if you supplied goods, services, or a loan. This is the language of 547C4, which is what we're looking at now. That's the basis of the subsequent new value defense. And this is the subsection that the court was looking at. 547C, the trustee may not avoid under this section a transfer. It doesn't say preferential or otherwise, it just says a transfer, A, not secured by an otherwise unavoidable security interest. I'll go into that double negative language in another video. It's not really relevant here. But the point is, the new value transfer, the loan, goods, services, whatever it is, that is not avoidable. And B, on account of which new value the debtor did not make an otherwise unavoidable transfer to or for the benefit of such creditor. This is the language in the new value statute is confusing. It's just, in my opinion, it's just very poorly drafted, and you could see courts struggle. Many opinions struggle to figure out what the double negatives mean. So it's drafted in a very confusing way. But in its simplest form, it's basically you're getting money transferred to you, you're being preferred, but you're putting money back into the estate, so it's a wash. I think that's the easiest way to understand it. Anyway, as to the court's ruling, it's pretty much how I described before. The court didn't decide whether it was a loan or not. And the point is, the court opined that it doesn't matter. Whether it's a loan, whether it's an investment, it's money. Money is money, and money is good enough. Well, I apologize. That's the bankruptcy court's decision. But you know what? It's the same holding as the Court of Appeals, so it doesn't matter. The Court of Appeals basically affirmed and just agreed completely that, money is new value, no matter how it's characterized. And the purpose of the new value defense, well, it's the rationale, is to allow a creditor to reduce the amount claimed by the estate as a preference to the extent the creditor replenished the estate. That's the takeaway. That's the important thing to remember here. And it's also, the takeaway here is if it's money or money's worth, at least in the Sixth Circuit, both are going to count as a transfer back to the estate that's going to be credited against a preferential transfer or alleged preferential transfer. I say alleged preferential transfer because there was no discussion as to whether the trustee met his burden or her burden under the laundry list that he's got to meet. So at this stage, it's an alleged preferential transfer. This is a bankruptcy court level case in Delaware. This is another new value case. Okay, the story here is that the debtor was in the drug business, pharmaceutical business, and the defendant, Maziz, was a former officer and director of the debtor, and also an owner of the debtor. Unfortunately, debtor's business ran into financial difficulty, and Maziz agreed to work for deferred compensation, I would say. The slide says without compensation, but as you'll see in the arguments made, what he's really doing is working for without immediate compensation, but deferred compensation, and who knows when he's going to get paid. But that was the concept. So the debtor agreed to $175K a year plus the $50K bonus as appropriate valuation of his services, and that was not disputed. Also, there was a specific arrangement made. There was a malpractice case pending prior to the bankruptcy, and the understanding was that if debtor got money from that case, then it would use that money to pay the deferred salary of this defendant as well as other folks. Well, lo and behold, they did get a large settlement from the malpractice case, and payments were made to compensate people on the money that was owed to them based on compensation arrangement. In other words, getting caught up with what was owed by the debtor. And of course, the defendant was one of these people that was paid. And then there's a bankruptcy filing. Trustees appointed and sues the defendant for a preference. Well, the debtor argued that, look, you knew unsecured creditors are not getting paid or that they're owed money. There's an imminent bankruptcy filing when you got paid. Then there was a bankruptcy filing. And you, an officer and owner, you get paid in full. And other folks are left holding the bag. So you got to give the money back pursuant to the preference laws. The defendant argued, hey, this just is contemporaneous exchange new value. I provided a lot of new value here. I'm not getting paid as a regular unsecured creditor. I'm protected by the new value defense because I did a lot of work. I worked, and that was my salary, and this just represents compensating me for all the work that I did. What's important here is that the defendant argued the contemporaneous exchange new value section which is different than the subsequent new value defense, which we just discussed in the last case. So let's take a look at that. Well, first we'll say what the issues are. Were the payments avoidable preferences? Did the defendant have a new value defense and or a contemporaneous exchange for new value defense? When I say new value defense, when I just say new value, I'm typically talking about the subsequent new value defense. So did it have any kind of new value defense? Subsequent new value, which is when you're providing new value after, subsequent to receiving a transfer, or did the defendant have a contemporaneous exchange of new value defense, which I'll go into in a second, but just like it sounds, it basically says you got paid by the debtor and pretty much contemporaneously you provided value back to the debtor. $547B, except as provided in subsection C and I of this section, trustee may avoid any transfer of any interest of the debtor in property. However, 547C, the trustee may not avoid under this section a transfer. And this is the contemporaneous exchange defense, 547C, 1, A and B. A, intended by the debtor and the creditor to or for whose beneficious transfer was made to be a contemporaneous exchange for new value given to the debtor, and in fact was substantially contemporaneous. It was a substantially contemporaneous exchange. So we're talking about, you get paid for bananas during the preference period, and you sell and you transfer the bananas at the same time. It's a non-credit transaction. That's the point. It's just a transfer of value for value. And this is the subsequent new value defense, 547C4. And the operative word, we saw this already, but the operative word is that after such transfer, such creditor gave new value. Well, the court took a look at the facts and decided that the defendant has a subsequent new value defense. As to the new value defense, the court held that after receiving the first payment, the defendant then provided the debtor with new value. So in other words, he kept on working after he got the payment and for 72 days. And the value of that is $34,520.55. That's subsequent new value. Why? Because he's not going to be compensated for that he wasn't compensated for that during the preference period because he'd have an unsecured claim. And it replenishes the estate, and it's a partial set-off of the preferential transfer that he got. Why is it preferential? Because the court ruled that the trustee met all the requirements of the elements of a preference in 547B that the trustee had to prove. So it is preferential. Question is there a defense to it? And here the court found there's a partial defense. As to the argument of the contemporaneous exchange defense, the court had to deny that. Why? Because the court found that there was no intent that the payment of the settlement funds was made in exchange in the contemporaneous exchange of services. The services were rendered during the prior year. They weren't rendered at the time or even near to the time that the settlement payment came in and the transfer was made to the defendant. There was no intent, and the judge didn't address the issue of whether it was substantially contemporaneous or not because there was no intent, or the judge found that there was no intent. I can understand why the defense tried to make this argument, and I've seen a lot of situations where there's payment of salary, and then there's the defense of, well, we provided services, and that's a contemporaneous exchange for new value. A lot of times, actually, that defense works because it's a different situation. A lot of time, the rendering of the service is much closer in time and overlaps and just continues with the time of the paying of the transfer that's trying to be avoided. So in the context of salaries, a lot of times the contemporaneous exchange works. But this was an unusual situation because no salary was paid for a long time. And then all of a sudden it was paid. And the judge did not apply the defense. I mean, you also could argue it certainly wasn't an extension of credit. Well, I guess you could argue that either way. Was there a debt created when the salary wasn't paid and then it was paid? Would that have been a claim against the estate if it had not been paid, if there had been no settlement? Yeah, I guess you could say it's a form of the extension of credit by the debtor, or rather by the officer to the debtor. Don't pay me now, pay me later. But whatever it was, it clearly was not contemporaneous exchange, and so the defense failed. In this new value case, the issue really is what kind of proof you have to show new value after receiving a transfer. It's really an evidentiary issue that the court faced. This is a 2006 case from California. And in this case, the debtor was a medical group, and the defendants are also apparently either doctors or nurses, doesn't really say what they are, but they're providing services to the debtor's patients on a fee-for-service basis. Trustees entered into a written agreement providing and authorizing the services, but there's a problem. The defendant couldn't find the agreement, and apparently the debtor didn't have the agreement either. So there's no agreement in the record, but there's testimony, as we'll see in a second, by the defendant that such an agreement existed. So the debtor wrote a bunch of checks to the defendant, and the debtor sought to recover the payments. So it was obviously these payments were made during the preference period, and trustee sought to get the money back. Well, the defendant claimed that it provided services to the debtor in the amount in total $27,313.84. The problem is that defendant didn't have any invoices either. It didn't have any invoices that explained exactly what kind of services, why the services were needed, didn't have a contract authorizing the service, didn't really have any evidence, and doesn't say in the opinion, but I'm assuming the debtor didn't have these records either. So what the defendant had was basically records saying, we billed on such and such a date, and it had testimony by the office manager of what kind of services were rendered, when they were rendered, and the value of those services, and the fact that there was a contract, but no one could find it. So really the question is this specific enough evidence for the judge to find for the defendant as far as new value that the defendant said it provided? So essentially, just to recap, defendant got paid, and then what it's saying is it continued to provide medical services to patients, and apparently was never paid for those services. At least in the opinion, it wasn't paid for those. In the opinion, it states it wasn't paid for those services during the preference period. Well, this is the applicable section again. and it's the subsequent new value defense. What they're saying is they got a check, they provided services after receiving the check, and the value of the services, in this case, is a partial set-off. Well, the court found that testimony of the office manager who was responsible for billing and the accounts was sufficient to prove that the defendant provided new value, and the court granted the defense to the extent that the defendant was able to prove new value. The defendant also had other defenses that are not relevant to this slideshow. This case involves a loan, and whether a loan, or rather credit card use, and whether that consists of a loan or whether that consists of new value. This is an Iowa case, 2008. At the outset, I have to say the amount here, the amount at issue is so low, and this is not actually the first ruling on this issue. This is a motion to reconsider, and there was actually a trial. I can't understand how this could have been cost effective. I don't know what lawyers get paid in Iowa, but to litigate a case for this amount to trial and then file a motion for reconsideration and have another hearing, I don't get it. But anyway, I guess lawyers don't get paid a lot in Iowa. At any rate, so the defense here is, the facts and defenses as follows. The defendant received payments from these individual debtors, but the individual debtors also used a credit card belonging to the defendants, and the issue is whether the use of this credit card, which essentially is a loan to the defendant, to the debtor, sets off the transfers that were made to the defendants, whether the use of the credit cards is new value. The other issue is whether the defendants can use this new credit card use to set off just the prior transfer, the one that was made immediately prior to the use of the credit card, or whether the new value can be used to offset any previous transfers that are preferential. So in other words, not just the transfer that the defendants received immediately prior to the debtor using their credit card, but also, let's say, a transfer before that as well. And that's an issue that the judge had to address. As you can guess, since everybody here is a Pickens, these were insiders. The facts in the opinion that I read doesn't go into the facts, but apparently these were all family members. I was looking for Boone Pickens here, and then when I saw that the amount at stake, I realized that he wouldn't be involved. Also, the trustee made an argument that this wasn't raised until a post-trial brief. It wasn't raised previously, and therefore the argument could not be raised. This is, again, the statute. Well, the court applied what's called the Garland rule, and that's a Court of Appeals case in the relevant Court of Appeals circuit for Iowa. And basically the decision was you can apply subsequent new value defense, not just to the previous transfer, but to prior transfers as well. And the court also found that use of a credit card is an extension of credit, and it certainly is valid new value, since you're extending credit. It's money or money's worth or credit. You're replenishing the estate. I included this case because it's an example of how a couple of defenses work together. A lot of times, defense lawyer is going to be using the new value argument and another argument, another defense, such as the ordinary course defense, and that was the case here. So I wanted to include this case as an example of how the new value defense can be very helpful once the ordinary course defense narrows down the the preference transfers that are not subject to the ordinary course defense. So this is the story of the sausage manufacturer and the meat wholesaler, and sausage was provided. I'm not going to include any pictures here for obvious reasons. Anyway, the argument was that the bankruptcy. This is a circuit level case, and the argument is that the bankruptcy court unduly restricted the number of transfers, alleged preferential transfers, that were made during the preference period, and found too few of them to be protected by the ordinary course defense. And the argument also is that there's a new value defense provided. That the defendant also provided meat products, and the value is $63,514 between January 18th, 2012, and the bankruptcy date, and didn't receive any payment for those sausages. Relevant statute is both ordinary course and new value. Well, the court found in this case, and I'm going to save the analysis for an ordinary course video, but it found that the bankruptcy court was too conservative in applying the ordinary course defense, and in fact the preference liability was limited to the payment of only 2 invoices totaling $60,679. This is important. This number is important because it's less than the new value that was provided. So on the second issue, the court found that the defendant provided sausage that wasn't paid for in the amount of $63,514, and this is a complete victory for the defendant. He doesn't have to pay anything because the new value sets off the entire remaining exposure. So that's how a defense lawyer would use the two defenses, and in this case, well, hopefully in every case, but of course that's not the case, wipe out the entire preferential allegation. This case looked at the issue of whether new value has to be paid for. In other words, you get a alleged preferential transfer, you ship product or render service after that transfer, and then that service or product is paid for later. So can you still use the new value provided to the debtor as a set-off, even though it's been later paid for? Most courts seem to say no. You can't use paid for new value. But this court disagreed, and the takeaway here is that some courts will allow you to set off new value. In other words, you make a shipment of product, you render a service, and that's paid for, and you can still use that product or service to set off a prior alleged preferential transfer. And the argument, I'll go through this case. It's a very complicated case, but the takeaway is paid new value can sometimes be used, especially in certain courts in Delaware, to set off a prior transfer. Well, the debtor cited a long list of cases and made the basic arguments, and the defendant argued that even though it's paid new value, it should be allowed as a set-off. And the argument, and the court adopted the rationale, is that Look, the vendor the vendor gets a transfer in the preference period from a troubled company, and based on that payment of prior goods or services, the vendor is shipping new goods or rendering new services. So it's relying on that payment. It's also extending new credit to what apparently is, or the vendor may know, but what is obviously a troubled company, since the company is about to file bankruptcy. And so the argument is that's new value by itself. New credit is new value because presumably the debtor is going to take this product or service and it's going to use it as a profit. That's why it's in business. And so it's probably, assumably, a profitable transaction for the debtor, and therefore it's new value for the debtor, and the debtor is getting additional unsecured credit. So the credit itself is new value, not the fact that it's getting product or services and then ending up not paying for it. It's the credit that's new value. So the answer in some jurisdictions is it doesn't have to remain unpaid. That's the statute. The other argument or rationale that the court seemed to adopt is that you don't want to discourage vendors from doing business with troubled companies. That's supposedly the entire purpose, or one of the main purposes, of the preference laws. You don't want to discourage vendors. And if you're going to punish vendors for extending unsecured credit, then the rationale is they're not going to extend unsecured credit if it looks like a company is troubled. And that's the opposite of what you want to do. You want to encourage unsecured credit, so maybe they won't file bankruptcy. This is another lawsuit by the trustee for the Global Medical Group. And I include it because it's a good example of the kind of evidence that as a defendant you need to supply to win on the defense of a subsequent new value defense. Okay, again, for some reason, both parties lost the written agreement as far as the contract authorizing services. So that wasn't available. Defendant wrote a check for $17K the debtor wrote a check for $17K and change during the preference period. Debtor argued that this was a preference and there wasn't any dispute as to the 547B elements, and the defendant argued that it provided, just like in the last case, not the last one, but the one we looked at before, that they provided medical services subsequent to receiving the transfers, and they were entitled to set this off. The difference in this case is that the defendant was able to find copies of the invoices that it rendered to the debtor. Again, the statute's always worth looking at. So 547B, just to spend a second on this, this is what was not contested in this case. This is what the trustee has got to prove. 547B, these elements here. 1 through 5, and it's not contested that he proved them. So then the defendant is able to present the defenses outlined in 547C, and this is one of the defenses, 547C4. So, as an example of how to prove the subsequent new value defense, here the defendant Vice President testified that services were provided at the appropriate time to make them subsequent to the transfers, and they provided new value to the debtor, and they were not paid. The defendant was not paid for these services. This is a direct quote from the opinion, and I wanted to include it because it does show what's necessary. Here there are invoices that that illustrate these factors. The date of the service, that's very important, because it's not, in other words, when you render an invoice, the date on your, and a lot of people are confused by this, the date on the invoice is not the date of the service necessarily. It's the date of the service or provision of the product or whatever new value is transferred. It's the date of the transfer of the value that's important, because it has to be subsequent to the preferential transfer. So the date of the service is very important, not necessarily the date of the invoice. What's being provided. Here there's an authorization code, the total charge, and then there's testimony that that the defendant did not receive compensation for the services. Again, the issue of paid new value and when paid new value may be acceptable is a complicated and disputed area. So for the purposes of this video, I'm going to refer to the unpaid new value as being part of the defense, but paid new value might be a defense in certain circumstances. Well, with specificity, when was the service rendered, what was rendered, wasn't paid for. The facts of this case are pretty unusual. In fact, I don't think I've ever seen a fact pattern like this, and the judge specifically said he's never seen a fact pattern like this anywhere. But it was an interesting fact pattern that forced the judge to analyze what new means in the context of the subsequent new value defense. So in this case, Globe Building Materials was the debtor. They manufactured roofing shingles, and the defendant was an outfit that built custom machinery. The debtor contracted with the defendant to purchase a machine and then entered into a complicated payment plan, basically an installment payment schedule. The defendant agreed to deliver the machine in component parts, and then they would be assembled on the debtor's premises. What's important here is that the defendant did not agree to, in other words, it wasn't a payment for each component, it was just an installment agreement, and the delivery of the component parts and the value of those parts were completely unrelated to the installment agreement. In other words, the debtor bought a machine, had a payment plan to pay for it, and the defendant, for whatever reason, was delivering the machine in parts over time. Well, apparently there was a bankruptcy right before or I take that back, right after the last installment payment, and the defendant had delivered the final component right before the bankruptcy, but after the last payment. So anyway, the defendant argued, okay, there's a bankruptcy, there's a preference action, trustees trying to get back the last payment, which was made during the preference period, and the defendant argued that it had a subsequent new value defense because it provided the last component to this machine after receiving the payment. So the defendant argued we provided new value to the debtor in the form of this component. Well, the two parties are arguing about the definition of new value. The debtor is arguing, hey, there's nothing new here. In other words, the defendant isn't providing a new loan, new credit, a new machine, not providing anything new at all. It's just providing the last component of a machine that the defendant already contracted, that the debtor already contracted with the defendant and paid for. And so there's nothing new here. Defendant's just complying with a prior contract. Just happened to be delivering the machine in parts. The defendant argued that the value of the component part that was delivered after receiving the alleged preferential transfer, and apparently there weren't any other defenses that were recognized, should be set off. We delivered a valuable component. We got the preference transfer, but after that, we delivered value in the form of this component. It's not fair that that's not going to be counted as new value. It's value delivered after the component. Again, the statute. The operative word that was looked at here is new value. And basically the court wrote an extremely long opinion trying to figure out how to apply the law to the facts when there weren't any cases that were similar to this fact pattern. And basically the court decided, and it's certainly a worthwhile learning experience reading the case, that there was nothing new here. There's no new value, and the court looked at all the subsequent new value, not all of them probably, but it looked at a lot of the subsequent new value cases in the fact pattern, and found in each of those cases where the subsequent new value defense was granted, the defendant provided something new that it didn't have to supply. Supplied new credit, supplied new products, supplied new services. And the concept is the defendant is rewarding for going out on a limb and providing something new in a situation where maybe the debtor's paying late, or there may be some knowledge that the debtor is in financial trouble. And so it's rewarding the defendant, it's rewarding that business or individual that's continuing to help this debtor during this period right before a bankruptcy file. Of course, neither party knows for sure, maybe the debtor knows, but usually the defendant who's extending new credit, product, or services does not know that there's going to be a filing. But the concept is it should be new. Here, the court found that there's nothing new here. It's just a machine or a part of a machine that the defendant had to supply anyway, or it would have been sued because it was apparently fully paid for at that time. And so the new value defense did not apply. So this is just another case where it's an unusual fact pattern, but can go into the storage of issues that might be retrieved later if there's a similar fact pattern. This new value case is an example of a situation that if the defendant knew there was going to be a bankruptcy, and if the defendant gave me a call before doing what he did, he wouldn't have had a problem. But neither of those two things are very likely. The problem with preference, everyone asks me, how do I avoid another preference case against me? And the problem is, if you watch my video called The Problems with the Preference Laws, one of the problems is you don't know when someone's going to go bankrupt. You just never know, unless they tell you, unless you have information, which most of the time you get the opposite information. Things are going great. I'll have plenty of money. And then a week later they file bankruptcy. So that's one of the things that make it almost impossible or difficult to prepare for a later preference case. Anyway, so in this situation, you have a landlord that had a tenant with problems. So the tenant, I'm assuming here it's a commercial tenant. Tenant didn't pay its rent, and landlord kicks him out, locks the door, puts a padlock on it, and then the tenant comes back and say, "Look, I want to get back inside, and I'll give you 50K if you allow me to re-enter the premises." Unfortunately for the landlord, defendant, landlord forward slash defendant, the 50K was paid in that magical 90-day period. Well, the landlord argued, "Hey, I provided new value. I provided a contemporaneous, and the landlord's using contemporaneous exchange of new value. He gave me 50K. I let him back in the premises." And so, it was a deal. It was an exchange. 50K, go back in the premises, and that should be contemporaneous new value. And in some aspects, it's certainly arguable. It seems like it might be. Definition of new value again: money or money's worth in goods, services, or new credit. So is this goods or services? Again, the code section. Well, the defendant landlord argued both kinds of new value. First, that it was substantially contemporaneous. Hey, it's let me in and 50K, it's a deal. Unfortunately, it wasn't contemporaneous enough. The payment was made 35 days after the debtor was allowed into the premises. So the debtor was allowed in. 35 days later, the landlord gets a check, and it's just too much of a time difference. And theoretically here, if the landlord got the 50K, and the same day that the 50K was received, the landlord or shortly after getting the 50K, which is how you'd think it would be done, but in this case, it just wasn't done that way. In that case, arguably, might have won on the contemporaneous exchange defense, but he still might have a problem, and the problem is the same as similar to the reason that the judge also declined the subsequent new value defense. The judge declined the subsequent new value defense because the debtor had provided the new value, letting the debtor into the premises first, and then after got the 50K that the trustee is trying to get back. If you provide new value, it's got to be after the transfer that the trustee is trying to get back. But here, it was provided before, and then he was paid the 50K. It was not subsequent new value. In this case, the new value came before the transfer, the 50K transfer. Also, for both defenses, there's an issue here on, is this really value? Is this value to the estate? I mean, it's not like building materials that's being exchanged for new value or contemporaneous exchange new value. It's not anything. It's not services. Not anything you could really evaluate. And in this case, the landlord was not able to obviously present the convincing valuation argument that letting the debtor back into the premises was worth 50K. In other words, it's not. The court looked at it and basically said, this is not really value. How does this benefit? How does this replenish the estate? How does this benefit later unsecured creditors? What's the value that they're getting? And it wasn't established. In this case, the landlord just didn't establish that there was value. All right, so new value must be after the transfer, and new value must replenish the debtor's estate, give some benefit to the debtor here. That just wasn't established. I mean, maybe it was tremendous benefit, but it wasn't established here for whatever reason. This case is another timing new value case where the issue of when to apply or when the new value period starts and whether that's receipt of check or the date the check was deposited or when it cleared. In this case, the defendant delivered petroleum products to the debtor. After shipment of goods to the debtor, the defendant would issue an invoice and the debtor would pay it. So that would be how they would typically work. After the bankruptcy, the trustee sued the defendant for a considerable amount of money, and these are payments that were made during the preference period. In this case, the court was faced again with a timing issue, and the defendant argued that the court should consider the date a check was issued when considering new value. And so why is it arguing that? Because then the defendant will be able to set off a lot more new value, because the new value has to be shipped, or the oil in this case has to be shipped to be counted as subsequent new value. It has to be shipped after the alleged preferential transfer or the preferential transfer. The oil has to be shipped after receipt. So the defendant is going to want to move that date further and further back, or to make it even clearer, earlier, wants that date earlier, so that because if it's later, then it's possible that the defendant ships some oil before the date of the transfer. So the date of the transfer, again, not to beat a dead horse, but the date of the transfer is very important. Because why? Because the new value has to be shipped or transmitted after the preferential transfer. Of course, the debtor's arguing the opposite. The debtor is arguing. So in this case, the defendant's saying the controlling date should be the check when the check was issued, which could be way before it was sent. It's arguable that issued means just cut. Maybe it wasn't even sent. So you're looking at a much earlier date. And then the debtor is arguing, of course, that the date should be when the check was honored, which is even after the receipt date, and it could be a while after the receipt date. If the defendant didn't deposit checks right away, waited a week, maybe he was lumping before depositing checks, lumping checks together, it could make a big difference as to whether the transfer, the shipment of oil was subsequent to a preferential transfer, or whether the shipment was before a preferential transfer. Again, the same statute. The court ruled that the applicable and controlling date of a preferential transfer for the purpose of applying the subsequent new value defense is the receipt date. Here, defendant didn't show when the receipt date was, so it got penalized a little bit, and for the purpose of the case, the court deemed that the receipt date was the date the checks were honored. And it turned out that it didn't really matter anyway, because the defendant was able to offset the preferential transfers by new value, that the oil that was shipped after the transfers. So the takeaway is, what's the date? What's the controlling date for purposes of new value? And it's only for purposes of new value, because you have different controlling dates in the bankruptcy code for different issues. So this is the controlling date that determines the date of the transfer for purposes of the subsequent new value defense, and it's the date of receipt. Well, these are the debtor, the defendant. Doesn't really matter for this case. I'm not going to go into the facts here. It's not really relevant. Basically, what happened is the defendant received a check on the exact same day that it delivered product to the debtor. And so the question is, and the product was not paid for, the check paid for previous product. So the question is, well, is that subsequent new value, or is it same day, is it not subsequent new value? Does it fall under that, or does it not fall under that? It was just sort of a weird fact pattern, but this stuff comes up, so it's worth knowing. And then and part of the same argument is whether it's the honor date of the check that controls when the transfer came in just for purposes of the new value analysis. In other words, the defendant here got a check on, let's say, January 15th and transferred product on January 15th. The check didn't clear until, let's say, January 20th. So is any new value, any product that's delivered before January 20th, is that not subsequent new value? Because it creates essentially a later date. You receive a check earlier than the check clears typically. And so it creates, it's worse for the defendant because there's fewer products are within the subsequent range, the range between the date that the new value transfer is recognized and the date of the bankruptcy petition. So anyway, that's an important issue because if the honor date is later, then it could knock out a lot of new value. This is the statute 547C4. Actually, that shouldn't be yellowed out. The whole thing is actually relevant here. Well, in this case, it wasn't clear what the transfer, it wasn't clear. Basically, the court ruled it's not the honor date, it's the receipt date of the check. And I'll talk about the rationale in a second. So here, these were two summary judgments that were before the judge, and neither one of them cited the receipt date of the check. And so the judge couldn't grant summary judgment to anybody, had to go back to the bankruptcy court it had to go back on the docket. In other words, the judge couldn't grant summary judgment. Either there's going to be more discovery, there'll be a trial, whatever, but there are not enough issues to grant the defendant's motion for summary judgment. It's defendant's burden to prove an affirmative defense. So anyway, it was denied for that reason. Now, as far as the rationale goes, basically the court was citing another case, and the rationale is the whole purpose is you want to encourage creditors from extending new credit, from delivering new product, to continue to provide services. Why? Because the whole point of not the whole point, but certainly part of the point of the preference laws theoretically is to prevent or to try to get companies to stay out of bankruptcy. That's the theory. Although I did a whole video which I already referenced. That I don't think that really works very well. So anyway, the theory is you don't want to wait. You don't want to make if theoretically, and this is a big if a creditor knew that the preference law stipulated that the time of the transfer was on the honor date, then theoretically, armed with that knowledge, the creditor would wait till after the honor date. I'm laughing because it's ridiculous, and creditors have no idea that there's even going to be a bankruptcy, let alone that there'll be a preference case, let alone what the rules are in a preference case. It's the furthest thing from anybody's mind. So I think it's ridiculous, a ridiculous rationale. But anyway, it's good for defendants. You want it to be the receipt date of the check and not the honor date, because you have more time to provide new value. So the conclusion is basically all this is dicta since the court didn't rule, but the court certainly seemed to take the opinion that the transfer date that the date of the transfer is the receipt date of the check, not the honor date of the check. Okay, it's a 2009 case. The debtor was in the business of manufacturing polyester clothing. Whether they were leisure suits or not wasn't stated in the opinion. Anyway, this is a new value case where the efforts by a defendant vendor to work with a debtor in financial trouble was actually rewarded. I don't even think I've ever seen that before in the context of a preference case. But what happened here was that the debtor was getting slower and slower, and the debtor was buying some kind of resin to use in the manufacturing process. But the debtor was getting slower and slower, and it reached its credit limit. And so the defendant, the vendor, basically said, look, I'll sell it to you, but the resin was needed, and there was, I'm not going to deliver it, but the debtor was, well, we need it here in case we need it, we have to have it. And so the defendant vendor said, okay, we'll deliver it on consignment. So that's going to stay in your location, but title's not going to pass. We're not going to actually sell it to you unless you have the money to pay for it, in which case you pay for it and we'll close the transaction. So that was the agreement, and of course things didn't work out for the manufacturer of polyester clothing, and there was a bankruptcy. Payments were made to the vendor during the preference period, and it's a new value question. The question is, what was the subsequent new value, and was it subsequent? So the defendant had delivered this resin to the debtor's location, shipped the stuff to the debtor, and the trustee argued, well, the relevant date here for the shipment of the new value is the shipment date, not the actual transfer of the title date. And it's very important because the shipment date of the new value came before the transfer, whereas the transfer of the title came after the transfer. So it was crucial to the entire case. What was crucial to the case is when the new value was transmitted to the debtor. And so that's the issue here, and quite a bit of money was involved here. Well, the same statute. I'm flipping through the slides because I just described the whole thing, but you can certainly read the slides for the exact dates, etc. Of course, this is one of the arguments that were made, 547CB, ordinary course. But we're focusing on 547C4. And the question is, to afford the benefit of credit to the extent that after such transfer, such creditor gave new value. So the question is, was it the shipment date, which would mean it's before the transfer, or was it the transfer of title date, which would make it after the transfer, which would make it subsequent? So the legal determination of that issue is very, very important. Well, the court ruled that the defendant didn't have an ordinary course defense, but who cares? Because it had a new value defense. The court ruled in its favor and found that the new value was transferred. The resin was actually delivered. The new value was actually delivered at the time of the release of the new value, at the time of the payment. Which was what the agreement was between the parties. So the court, the important takeaway here is, as far as the date of the delivery of the new value, the court is going to not just look at the shipping date, but it's going to look at what actually happened and the contract between the two parties. of course, if the shipment date, if there's not a consignment agreement, and the shipment date is what controls, and there are other issues. Is it when it, is it when it was shipped or when it was received? Who had title during that process? And this issue is going to be argued about a lot because of the way the statute is constructed. This date is crucial, and it could mean the difference between paying back $500,000 or keeping your $500,000. So these issues are going to be beat to death, basically. This case involved another timing issue, and what happened here is that a lot of new value was shipped after subsequent to alleged preferential transfers, but the dispute was that for some of these shipments of product, some of the product was later returned, and so the question is, should the new value be reduced because some of it was returned and then a credit issued? So I think it's a fair argument by the debtor, by the trustee. You didn't ship as much new value as you say you did, because a lot of it was, or at least some of it was returned. So not as much was shipped. And I basically summarized. I'm going to go right to the conclusion. Of course, that's the statute. I thought the ruling was interesting because commonsensically you would think, yes, it's less new value because some of it was returned. It was returned pretty fast during the preference period before the bankruptcy. But the court ruled that it doesn't matter. The point is the point is the new value was extended, it was shipped, and the court looked at some other case law, and the timing and the value is when it's shipped, and not even when it's received. The point is the point is that you want to encourage folks to do business with troubled companies. And so the judicial interpretation of the statute should be aligned with furthering that policy. If you're going to punish vendors that these folks are going on the line. They're shipping product to, in most cases, to a company that's pretty shaky. After all these companies did file for bankruptcy, a month or two later, or even sooner, and you want to encourage vendors from doing business with troubled companies. So if you reduce the amount of new value that they can apply to set off against prior preferential transfers or allegedly preferential transfers, you're not granting. You're basically not. If you read between the lines, the court is saying you're not supporting the spirit here. You're not acting in the spirit of Christmas here. The spirit of the new value defense. You want to encourage these folks, not discourage them. You don't want to nickel and dime them and say that because some of it was returned, you don't get as much credit. No, you want to encourage these folks that are going out on a limb here. Anyway, I'm getting a little too excited, but I think that's the spirit of the decision. This is a case from Iowa, pretty recent case, involved a kosher meat packing plant and another entity that was in the business of supplying kosher meat products. But this is a new value case again. Of course, this is a new value video, so it's going to be another new value case. I mean, there are other defenses that are made, but I'm not going to go into those. But it's not a vendor extending new value. This is a I believe it was a cousin of the owner of the debtor. So this was a family relationship, and it was the defendant was an insider, a non-statutory insider, and it was also not a situation where the defendant was a vendor giving product or services. This was a lender borrower relationship. So in other words, the defendant would lend the debtor a number of short-term loans, totaling quite a bit of money. But there would be a pretty regular financing arrangement here. It would be a loan, it would be paid, it would be a loan, it would be paid, and at some point it was all informal, no contracts, and no interest. And if you know anything about Judaism, I assume this is what was called a mitzvah. At any rate, debtor goes bankrupt and sues the defendant for a number of things: fraudulent conveyance, constructive fraudulent conveyance, and preferential transfers. Of course, not the debtor, the trustee. And the defendant made, a million arguments. It's ordinary course. It made every argument you can make. It sounds like if you don't like this argument, I got another argument. It just made all arguing everything. One of the arguments it made was, well, the short-term loan arrangement, I lend the money, I get paid back very, very quickly, and this is a contemporaneous exchange for new value. That's one of the arguments. Another argument is that these unsecured loans were new value that are going to set off alleged preferential transfers. And of course, it's the year look-back period, because the judge found that the defendant was a non-statutory insider. Well, a lot of different issues here, and I'll go into the new value issues. There's the statute that you have memorized by now. Well, the court found that, first of all, it can't be I'm not going to go into the fraudulent conveyance aspect of it. It's not for this video. But the court looked at the contemporaneous exchange argument and found that that's impossible, because the whole purpose of the contemporaneous exchange is that it's not a credit transaction. That's the entire raison d'etre of the contemporaneous exchange defense, that no creditor is created. And so the court said it's not appropriate because this is a short-term loan. So it's not a contemporaneous exchange transaction. It can't be. As far as the subsequent new value defense, the court bought that and disagreed with the trustee's argument that there was no showing that it wasn't paid back, or that it wasn't unpaid, and that it didn't replenish the debtor's estate. And the court said the defendant gave money to the debtor. Money. It falls right within the definition, and of course it replenished the estate. It's obvious. Unfortunately, that wasn't a very big number compared to what the defendant was being sued for, but it did grant a subsequent. It did rule that one of the preferential transfers could be offset by new value. This is a 2010 case, Northern District of New York, and the issue. I included this case because it gives you sort of a flavor of another example of when new value comes into play. And it's also raises some other issues that are worth taking a look at. So you can read the slides. I'm just going to summarize it. You have Bruno Machinery, you have Troy Die Cutting, and essentially what you had was a very close relationship, family relationships. The court did find that the defendant was a non-statutory insider because of the family relationship, because it's not arm's length bargaining. Basically, what you have is a series of loans and repayments from the defendant. The defendant makes loans to the debtor, debtor repays them. There's a question of whether the repayments are constructive fraudulent conveyances or preferences. I'm just going to, it's not really a new value issue, but it is a general clawback issue. And if there's no antecedent debt and there's money being transmitted from the debtor to another party, then you have a situation where there's a potential constructive fraudulent conveyance or actual fraudulent conveyance. In other words, if the money's going out and it's not paying a debt, why is it going out? Unless there's an argument there's a contemporaneous exchange, why is the money going out? And so if there is an antecedent debt, then there's the possibility of a preference. And so as a defendant, you're caught between two unappetizing choices. If you admit that there's an antecedent debt, then you're being subject to a possible preference here. And here the reach back period is a year, which is a long time. And if you argue, well, there's no antecedent debt, therefore it can't be a preference, then you're subject to a possible fraudulent conveyance action, either constructive or actual, and you have to deal with that. So whether there's an antecedent debt or not is an issue, but it's hard to avoid. If you're arguing that there isn't an antecedent debt, unless there's a contemporaneous exchange, it's hard to avoid then being sued for a fraudulent conveyance. Here the defendant argued that there's new value, and I'm going to jump to the new value issue here as well. The defendant argued that there were new loans. Therefore, the defendant replenished the estate. In other words, when the defendant was paid, it made another loan. Then it was paid for that loan. Then it made another loan. It kept on extending credit to the debtor, and that should be counted as new value, regardless of the fact that these loans were repaid during the year-long preference period. So what's important, the defendant argued, is, hey, we're making loans to the debtor, and from a pure policy perspective, the court should be encouraging that. Shouldn't be punishing us. We tried to keep this debtor in business. Of course, these are all the relevant statutes. 547B2, on account of an antecedent debt. So, basic preference law, that's one of the elements. There's got to be an antecedent debt. If not, it's not a preference. Could be a fraudulent conveyance, unfortunately, but it's not going to be a preference. There's a reason for that, because we're, going back to very basic concepts. Who are we protecting? What's the class of folks that are being addressed by a preference? It's unsecured creditors. Creditors are being protected, and the class of creditors that unsecured creditors are being protected from are other unsecured creditors that are being paid in full. So we're dealing with credit transactions. We don't want some unsecured creditors to get paid in full in a situation where it's inequitable to unsecured creditors that are getting bupkis after bankruptcy is filed. Well, the court ruled that since the loans were, and I'm focusing on the new value issue here, the court ruled that since the loans were repaid prior to the bankruptcy, then the defendants cannot rely on the new value defense. Courts differ on this. Courts do differ on this. This is a an issue that where you'll find a split in the circuits. So this is another court in another place at another time may find differently, but this is the law in New York currently. And when I say this is the law in New York, I'm talking about the specific issue. Can paid new value um, um, ever be a set off, ever be a defense to a preference case? And in Delaware, they have a different opinion.